SJC-13507, Business Interiors Floor Covering Business Trust v. Graycor Construction Company.
Okay, Attorney Lysiak?
Madam Chief Justice, and may it please the Court, Matt Lysiak for the Graycor Construction Company, Incorporated. Just a brief introduction in terms of this case. This involves a large construction project at the what was called the Hub on Causeway, which is at the North Station. It's a large construction project at the North Station. This involved a construction project which Graycor Construction was the general contractor and was tasked to build a theater at this facility for an original contract price of $18.
Counsel, I'm sorry to interrupt you.
Yes.
I know I'm familiar with the facts. I think my colleagues are as well. Can I ask you just to sort of dive into the argument and maybe start with your argument about the lien?
Absolutely, Your Honor. So the first argument being, and what we're essentially here for, is to talk about the impossibility defense that Graycor has put forward.
When did Graycor put that forward?
So Graycor essentially put that forward in the opposition to Business Interiors' summary judgment motion, which was filed in June of 2022. And
when did the case get started?
The case actually got started in 2020, in September of 2020.
So the first time you mentioned it was in 2 years later?
Yes, Your Honor, in the opposition.
So tell me why it's not waived.
So there's a few reasons why we believe it's not waived, Your Honor. First off, although it wasn't mentioned in the affirmative defenses, and I do believe that was a clerical error on our part, this motion, these cases...
Is that a doctrine of...
Clerical error.
Yeah, I mean, I guess, what do you mean by clerical error, and how does that fit within our jurisprudence of waiver?
So, Your Honor, so it doesn't fit within your jurisprudence. I'm simply explaining how it occurred. So there are several cases that were consolidated in the trial court. Several of them, the majority of them, had frustration or purpose affirmative defenses that were alleged. This matter was put forth at the end of those consolidated cases. I believe it was the fifth in line. And it simply did not contain an affirmative defense. However, there's a number of arguments that we'd like to make in terms of why we feel that it is not waived. First off, the cases in which the appellee cites regarding the affirmative defenses and whether those are waived if they're not made at the time of an answer, those are generally not allowed because they are presented at the time of trial. Here, there's that summary judgment. We're arguing that there's going to be additional potential discovery that would need to be done if this is allowed to go forward at the trial court. And then Rule 15A allows for amendments to pleadings to be made freely with leave of court. So we would suggest that Business Interiors was also did know about this particular affirmative defense, namely because there was other subcontractors that had filed cases in the consolidated actions. There were the affirmative defenses that were put forth there. There was additionally a summary judgment with one of the subcontractors in which...
Any cases in which a related case preserves an affirmative defense that wasn't brought up in that case? Anything you could cite to where we have approved that or the appeals courts approved that?
In which there was at the summary judgment level?
Just any time in which you failed to bring up an affirmative defense, but because there's a case involving another subcontractor or another, somewhat related case, that preserves the affirmative defense?
No, Your Honor, there isn't anything on point regarding consolidated cases. Although, again, I would point out that the cases that are cited in the appellee's brief, again, are all cases in which the defense is made right at the time of trial. So with that, and additionally, Your Honor, in terms of the discovery that was presented, the defenses that were made are essentially impossibility defenses, effectively that the contract could not be completed. So although the The words frustration of purpose and possibility are not mentioned in the affirmative defense. Our arguments are that the contract could not be completed as they were made. So, and this effectively goes back to...
And did that argument include reference to the pandemic?
It did not, Your Honor.
Did not, okay.
It did not. But again, the idea is that essentially there's an aspect of the contract that needed to be approved by a entity, this being Pacific Theaters, which was not able to approve these invoices and payments applications for payment. And the reason for that was because of the pandemic.
Well, you could have raised that when the requests for payments were made, right?
So, Your Honor, so essentially at the time in which these payment applications were made, which was in March and May of March and April of 2020, the pandemic had started. Right. At that time, Pacific Theaters had stopped operating. So there was essentially no way that...
Statute contemplates that if there's a request for payment, you need to explain why you're not making payment, right?
So right. So the statute basically asks for an explanation based on the contract, well, why that you can't make it, and you have to make that with a good faith certification. Although that's not truly determined at this point in Massachusetts what that is.
You could have said, "I'm not making payment because under the contract, you don't get paid till I get paid."
That could have been said, Your Honor. However, what I would suggest is that ultimately to make that determination, we need contact from Pacific. They're the ones that make that determination. So the Prompt Pay Act really doesn't address this situation where there are payments.
I thought the Prompt Pay Act basically says anything to the contrary in the contract is void.
Anything listed.
You can't contract your way out of the Prompt Pay Act, essentially.
That's correct, Your Honor. So you can't have paid if paid clauses, essentially.
And how is this not one of those clauses that's voided by the Prompt Payment Act?
So the issue here is that it is not so much the payment that comes from the owner down to the general contractor. It is the approval of the work that was actually not performed. So here, in order for to get any payment from the owner, this being the tenant Pacific, down to Graycor and then subsequently down to the subcontractors, Pacific needs to actually review the work, review the invoices submitted by the contractors, and then actually give payment, remit payment.
Right, so it sounds like I have to get paid in order to pay you, which is exactly the kind of provision that the Prompt Payment Act was designed to void.
What I would suggest, Your Honor, is that in this case, the Prompt Pay Act really doesn't address a situation where the general contractor can't actually approve of the work. So there is a distinct difference here. So, as opposed to, say, the Tachi case in which you had an owner and the contractor in which the owner would approve of the work and then actually would remit payment. Here, there's another level. So essentially, the contract is between the subcontractor and the contractor. The contractor pays, but ultimately, in order for them to do that, they need to have the work approved.
Isn't that very common in construction? And I guess I don't understand your argument that the Prompt Payment Act doesn't address the issue when it specifically talks about tiers of contracts.
So
Can you just explain that?
Yeah, sure. So the Prompt Pay Act doesn't just exclude or it doesn't just include contracts. It includes subcontractors as well. So obviously here, subcontractor can make a Prompt Pay Act against the contractor. But in terms of the level of approval, the Prompt Pay Act doesn't state that the approval needs to be done by another entity, right? So the Prompt Pay Act actually talks about the contracting party. Here it would be Graycor. So the Prompt Pay Act in and of itself is what I would describe as is somewhat flawed in that respect. It doesn't actually address these situations where you have these separate entities that are approving of work when they're not the actual contracting entity with the person that's bringing or the entity that's bringing the Prompt Pay Act claim. So again, this,
So I have there's just two issues that I have with the position that you're needing to take on appeal. And it's the following. The first is that you never told BI that this was your argument in rejecting. You just neither accepted nor rejected their application for payment. And under the Prompt Pay Act, it seems like that means that you need to flow the money to the subcontractor. And then the second is, I think, what you were currently addressing, which is that I don't understand how this is not an end run around the provision of the Prompt Pay Act that says I get paid and then you get paid. Those kind of provisions are void.
so what I would say to that is that essentially, like as you noted, that this does happen in construction contracts. The issue here is that it would cause chaos. So effectively, you would have situations where Graycor would have to reject payment and tell Business Interiors that they had rejected payment with or without the actual consent or without any knowledge from, say, Pacific. Pacific has done nothing to actually approve of the work.
That's because of the pandemic, though, right?
So in this case, it's the result of the pandemic. Yes.
But just so I'm going to ask you the question, I didn't know if you answered it or not, that every construction contract that requires approval of works, someone has to sign off on work. So how can the sign-off be a way to get out from under the Prompt Pay Act?
Well, so Your Honor, I think this, again, the Prompt Pay Act doesn't address necessarily what's going on here. There's $32,000 in this amount that is now due according to the trial court that was actually asked for by the owner. So essentially what the trial court's saying is that Graycor is on the hook for essentially a portion of this money owed that they had nothing to do with actually requesting. It was simply passed through Graycor, went to the owner. So
You have an indemnification provision with the owner? I mean, there's ways that a general contractor can cover themselves, right?
there is, Your Honor, but not in this case. So
Okay.
in terms of...
So there were ways to cover yourself for the eventuality of the owner going directly to the subcontractor, but Graycor chose not to employ any of those mechanisms.
At the time in which this occurred, Pacific wasn't doing anything. So
Don't you say, I'm a little confused. I thought the contract has a provision for this, that the owner requests a change order, right? Isn't that in the contract? I thought you were arguing.
It is, Your Honor. It's in section 5.4.
So it was contemplated by the parties that the owner would make a direct change order request, right?
Yes, Your Honor. But the idea is that if...
And the contract didn't say, and the owner will directly pay for this, right?
No, it didn't. There's no provision within that. So essentially what would happen is that it would come from Pacific, the owner, down to Graycor. They would filter the information down to the particular subcontract that was doing the work, and then...
This is normal, right? I mean, that happens all the time in construction contracts, does it? The owner sees something going on in a large construction project and asks for some kind of change, and it increases the value of the contract.
Yes, of course, Your Honor. But again, in the terms of the Prompt Pay Act, in terms of approving that work, taking the invoice, looking at what the specific work that's being done, whether it's appropriately priced out, whether the work was complete, that at least for $32,000 worth of that work went directly to the owner. But the trial court is essentially saying that Graycor now is on the hook for that. And we believe, at least for that amount...
I take it you directed the sub to do the work, right?
Only to the extent that it was delivered information from Graycor from Pacific to Graycor to the sub.
I guess pertinent to a claim that we're going to ask other counsel about, you're on the hook. The PPA requires the payment to go, but as far as ultimately, this just basically shows who's going to bear the initial burden, right? Because you still have a lawsuit at the end of the day.
Yes, I mean, yes, Your Honor. So,
Right, and the PPA is basically telling the subs that you're not going to be starved out. The GC is going to take the hit, and then we'll litigate.
that is correct, Your Honor. But again, you know, in this situation, I think the PPA unfairly puts the onus on Graycor, or the general
Go to the
fund.
legislature and tell them that, not us.
Understood, Your Honor.
Okay. Any other questions?
No, thank you, Chief.
Counsel, can you kindly please walk us through your understanding of what would have occurred if Graycor had, within the time period, lodged the objection and said, we received your request for payment. Unfortunately, we can't do that right now because the work has not yet been approved, and our reading of the contract is that we cannot pay you until it's been approved by Pacific. We've been trying to reach out to them. They have not been responsive. Can you walk us through your understanding of, under the contract, what would have then taken place?
Nothing, Your Honor. We would be in the exact same place. Essentially, they would have submitted the
I'm sorry, counsel, to interrupt, but isn't there a dispute resolution requirement under the PPA?
A dispute resolution?
Right, there's an application and then you reject it, it must go to a dispute resolution. The whole point is to not allow the cash flow to stop, that there are timeframes during which the cash flow will stop.
Yes, but that
So when
doesn't.
you say nothing will happen in response to Justice Stewart's question, I don't understand that.
So and maybe that was inartfully framed, but what I'm saying is that essentially the subcontract can bring another breach of contract claim, whether it's under the Prompt Pay Act or not. So if we reject the claim and then at a certain point Business Interiors brings a breach of contract, we're still in violation of the contract. We still didn't pay, even though we gave a rejection. It's still in violation. They did the work. It was not paid for. We submitted an application, or excuse me, we submitted a rejection, but ultimately they could still bring a claim against us for breach of contract, regardless of the PPA.
Okay. Thank you very much.
Thank you.
Okay. Attorney Forgione.
So, good morning, Your Honors. Andrew Dennington for the Appellee Business Interiors Floor Covering Trust.
I'm sorry. Thanks. Oh, it's my fault.
So this court should affirm the judgment below because the motion judge correctly entered summary judgment in favor of Business Interiors. I first want to pick up on some of the points that the panel raised in the colloquy with the appellant's counsel. First, it is indeed the case that the affirmative defense of impracticability was waived because it was not pled in the answer. And I think the court should consider what's the purpose of that rule in Rule 8, that affirmative defenses have to be pleaded. The purpose is to provide notice to the plaintiff so that the plaintiff can...
Could they have amended their pleading?
Yes, they could have.
Okay.
And they
so,
did.
and so when is the end date that they can amend their pleading?
There is no prescribed end date
So why
because,
can't they do it now?
well, that would be, in my view, highly prejudicial to...
But, so can you explain that? What
Okay.
is the legal test for when somebody can amend?
The legal test, leave shall be freely given under Rule 15, except if the trial court were to find that it would be unduly prejudicial to the plaintiff. And here, it would have been because during the discovery phase, if you look at the request for admission, they're at page 171 of the record, you'll see that Business Interiors served written discovery to Graycor asking, what was the basis, why didn't you pay? And the response were, they cited to the pay if pay clause in the subcontract, which is overridden by Section C of the PPA, which...
So they cited to 5.4?
Correct. So we had no notice that they were relying on a COVID-based impossibility defense until after discovery had closed when we received their summary judgment opposition. That was prejudicial in that if we had received earlier notice, we could have, for example, fleshed out, well, what evidence do you have of your own, of your own financial condition? At the end of the day, it's, I think, irrelevant because, even if there wasn't a PPA, this still would not have been a defense that generated a triable issue because one of the essential elements of impossibility is that the defendant has to show that its own performance, in this case, inability to pay, that it was unable to pay. And there's nothing in the summary judgment record where Graycor demonstrate it was impossible for us to pay $127,000 to Business Interiors.
Can you walk me through the argument that Section 5.4 is void under the PPA?
Yes. So Section 5.4, it says, the subcontractor understands and agrees that the contractor can only make payments to the subcontractor for monies paid to the contractor by the owner for the work. Consequently, but subject to any applicable statutory requirements relating to payment, the subcontractor also understands and agrees that the contractor's obligation to pay the subcontractor is totally dependent upon the contractor's receipt of such payment for the work from the owner. But then the PPA in Section 3 says every contract for construction shall provide these conditions. And then Section E provides that a if-pay clause is unenforceable unless a certain condition is satisfied. And I think that's significant. The legislature already contemplated a scenario where a general contractor would have difficulty making payment downstream based on the financial condition of the upstream payer. And the legislature decided that there would be several conditions that would need to be satisfied. The first of those is that the upstream payer had to be insolvent or become insolvent within 90 days of receipt of the submission of the application for payment, and that simply didn't happen here. Pacific ultimately did file for bankruptcy, but the reason why Graycor never attempted to, prove up this exception was because it didn't file for bankruptcy until June 2021, so that's well past 90 days past the last of the 3 payment applications in question. So, I think this illustrates that it's a situation where the legislature in 2010, after a very, has a carefully crafted scheme, and there is a kind of escape valve to the reject or pay rule if you can meet certain conditions, and they just weren't satisfied here.
Sorry, can you please answer the question that I posed to the other side, which is, what is your understanding of what would have occurred if Graycor had,
Yes.
within the time, promptly said, sorry, we can't pay you yet because the work has not been approved?
What it would have done is it would have accelerated this case, all right? And one of the purposes of the PPA, it's not just to ensure prompt payment of invoices, but also prompt resolution of disputes, right? So if that was indeed the defense, I'm going to raise a COVID-based impossibility defense. Those types of arguments generally have not been very successful. I think it would have accelerated Business Interiors filing suit earlier would serve the purpose of the statute. Let's resolve these disputes sooner rather than later. And the fact that Graycor has asserted this impossibility defense, for the first time after the close of discovery, is running contrary to the purpose of the statute.
Speaking of acceleration,
Yes.
can you, and I recognize that you note in a footnote in your brief that the other side has not raised this issue, but could you talk me through the propriety of the 54B separate final partial judgment in this case, where I think it's fair to say there is quite a bit of interrelationship between the remaining claims and this claim?
Yes. So, as the court is aware, the appeals court in Tachi held that to effectuate the purpose of the statute, there's no just reason for delay in entering judgment after there's been a violation due to the PPA. So that's so that the
I understand how it suits the statute's purposes, but the Tachi case does not discuss the 54B standard in any detail. So could you please address the standard that we are our court has generally taken a rather dim view of piecemeal appeals. So could you explain how this would work? Because now, of course, the case is going to go back down potentially for further litigation, correct?
Well, okay, answering this, so there's kind of two questions there. So if this judgment is affirmed, what our intention would be is, we don't need the rest of the claims. We would stipulate to the dismissal of those claims, and then we would bring a petition for award of our attorney's fees pursuant to Article 10.2 of the contract, and then have one amended judgment after rescript that included this judgment plus all the attorney's fees, and then go off from there. We wouldn't need, claims for breach of implied contract. We wouldn't need unjust enrichment claims against the, now then, what would you do with the cross claims, right? That, I think, really illustrates why a purpose of the statute, why it was appropriate to enter separate and final judgment, because if it has been determined as a matter of law that Business Interiors is owed this money, why should Business Interiors' ability to get a judgment and execution and start to collect that money wait until Graycor says, wait, I want to see if I can get the money back
But
from
surely you
Pacific
understand,
and
I'm not
Kodak.
saying that it's this case, but surely there will be situations where someone requests payment under the statute, the other side rejects, or sorry, the other side untimely rejects, but has a really good defense to payment. And so in that situation, how is this all going to unfold? In that situation, is it appropriate for the lower court to enter a 54B judgment, to have an immediate appeal on the timeliness of the rejection while we still have pending below all the good reasons why actually they should not have to pay?
It's difficult to answer a hypothetical based on facts that we don't have in front of us, but if I can just compare it, for example, to the Tachi case, okay? In the Tachi case, the owner vigorously protested, this is just unfair, right? That I have meritorious counterclaims back against the contractor. For example, they alleged, you've overbilled me, you falsely submitted payment applications, and to effectuate the intent that you have to, as Justice Gaziano said, you have to let the money flow, right? And then we'll fight about this later.
But
right?
there are lots of statutes that have really important purposes where we want to get people money, but Rule 54B still is a pretty stringent standard. For example, the Wage Act, like everyone should be paid the money
Yes.
that they earn and so forth. So can you speak really practically to the question, which I think is the pertinent question under 54B, is there a way to understand the Prompt Pay Act claim here as somehow not intertwined with the rest of it? Because it's just a simple question of did they meet the time standard or not? I think it's complicated because it's essentially a breach of contract claim, correct?
Yes.
So it's complicated to say that there's a breach of contract claim that is not intertwined with the other breach of contract claims of the same contract that the other side has. Do you think that they can be sort of severed from each other as not intertwined in an improper way vis-a-vis 54B?
Well, I can understand your point, Your Honor. I think count one is breach of contract. Count two is breach of implied contract. All I can say is kind of a practical matter is that count one is the flagship claim. And a lot of those other claims are kind of pled in the alternative. So for example, it's common that if there hadn't been
I don't
a
think
PP.
that the issue really is about your claims. It's about the counterclaims.
The cross claims.
Yes.
Yes. So
Right, and so given that the two are intertwined with the contractual bases, normally under 54B, we wouldn't allow a judge to enter separate and final judgment on one claim that is implicated by a cross claim.
normally, you would not, but here, I think there is benefit into having entry of separate and final judgment so that, as I said, the entity that's owed the money can immediately collect the money as it's entitled to under the statute. And then what would be left of the cross claims is essentially the general contractor chasing the owner.
Can I,
So it's okay here, in your case, to have separate and final judgment?
Yes, it is okay to have
But what
separate and
about,
final
what
judgment.
about, what about the other cases? I think that's the point. I mean, what's the rule you're asking us to, what do you want us to say here? That sometimes you can do it because it looks like the cross claims aren't going to work?
Okay, well, you know, if I can use the question about, for example, the Wage Act as a, you know, as a reference point there, you know, I think that this statute really emphasize, it has certain provisions where you have to accept or reject within 22 days, and then you have to pay within 45 days of an approval. It's a very, very detailed regimen, and without having the Wage Act right in front of me,
Isn't
don't
the
think there's
purpose of the PPA to basically level the floor on the power disparity between the
Yes.
GC and the sub? So
Yes.
that there are subcontractors who become bankrupt in
yes.
projects when, if they don't get paid, they can't wait for the final litigation.
Absolutely, and I think, now fortunately, that has not happened here, but this really, the fact pattern we have before here is really exactly what the statute was designed to prevent, which is a subcontractor performs work, sends the invoice to the general contractor, and the general contractor just ignores it, and then forces the sub to chase the general. In their intervening time period, the sub has to, you know, maybe out money for its suppliers. It has to pay an attorney to chase the
can I ask a technical question?
Yes.
We're going to lose you. And the definition of contract for construction.
yes.
A contract for which a lien may be established under sections 2 or 4 of chapter 254. That, you couldn't get a lien here, right? So I'm just, how do we make sense of that? Is that just bad drafting by the legislature?
Well, I would say this. I agree with the ASM brief that what's intended there is it's intended as a shorthand reference to the types of contracts that are subject to the PPA. So
It's a sort of a strange shorthand, isn't it?
I can understand the point Your Honor's making. However, how I interpret it is, in the lien law, there is this kind of verbose language which defines what is construction. It's for the alteration, repair, or something of improvements to real property, et cetera. So the legislature, instead of just copying and pasting that, you know, language and then having a longer definition of contractor for construction, it just imported the definition from the lien law, and I guess it also, so that's my answer to your question.
You could have just written, you know, contract for construction, sort of self-explanatory in many ways.
Yes, this is indeed a contract for construction.
It's a contract for construction, certainly, but it's not a contract for which a lien may be established against the contractor, I mean, against the GC, right? Because they don't own the property.
So then, if I could, I see that I think over time, but just one last comment, which relates to this argument. This is another argument that was not properly preserved because the fact which anchors this argument is the lease termination. The lease termination in the record at 433 was not part of the summary judgment record. So the trial court could not have erred in failing to consider this argument that was based on a fact which wasn't in the summary judgment record, was just slipped into the back of the appendix for the first time, and is the subject of our unopposed motion to strike.
Argument is not something that was made at summary judgment?
It was made for the first time in oral argument on the summary judgment motion, but there is nothing in the summary judgment record about the lease termination.
Gotcha, okay.
But, I'm sorry, Chief. Is there, I'm sorry, I thought that under Section 4 of the Lien Act, you could, at the time you entered into the subcontract, your client entered into the subcontract, there could have been a lien established on the leasehold. Is that incorrect?
Well,
That's
what
how
they
I
could
read.
have, they could have filed a notice of contract. There's a series of steps. Notice of contract, statement of account, and then ultimately you file an action to preserve the lien, and that provides, you know, security for a claim like this one. So I also think that
But I guess given the fact that, I think it was Pacific, was leasing the property, right? Was a lien available to BI under Section 4?
I believe a lien was available to BI, but they
So
just
all it
didn't.
has to be is a contract for which a lien may be established.
Correct,
right?
correct.
Okay.
And I see that I'm out of time, but thank you, Your Honors.